judgment in the appeal, the Queen against Brown.
The judgment in this case will be given by Lord Kerr.
In Northern Ireland, if a man has sexual intercourse with a girl under the age of 14, he commits a criminal offence. It doesn't matter that she may have agreed to have sexual intercourse, nor does it matter that he believed that she was 14 years or more. That was the decision of the Court of Appeal in Northern Ireland in dismissing an appeal by the appellant against his conviction of the offence of having unlawful carnal knowledge of a girl under the age of 14, contrary to Section 4 of the Criminal Law Act 1885. The appellant was 17 years old when the offence took place. The young girl with whom he had sexual relations was 13. He told police that he believed she was older, and that claim has not been disputed by the prosecution. He therefore appealed to this court against the decision of the Court of Appeal. On his behalf, it was argued that it was necessary for the prosecution to prove that he knew that the girl was less than 14 years old, or at least that he did not believe that she was 14 or older. This court unanimously dismisses his appeal. There is a strong constitutional principle that knowledge on the part of a defendant of all the elements of an offence is presumed to be required in order to establish criminal liability. But that presumption can be displaced where it is clear that Parliament intended that this should be so. This court has concluded that there is no doubt that Section 4 of the Act of 1885 in its original form was intended to impose criminal liability for carnal knowledge of a female under the age of 14, without the need for proof that the perpetrator knew or had reason to believe that she was below that age. Various amendments to the Act of 1885 have been made, but that central feature of Section 4 has been left untouched. The fact that the appellant believed that the girl was 14 or over was therefore irrelevant. This outcome may appear harsh to some. In answer to that view, 2 points must be made. Firstly, Parliament has decided that this should be the law, and it is the duty of this court, as it is the duty of all courts, to apply the law which Parliament has enacted. Secondly, the policy of the legislation is to protect children. If you have sexual intercourse with someone who is clearly a child or young person, you do so at your peril.